Yeah, let's try to finish off this somewhat lengthy chapter. And we'll talk about influencing agency decisions, right? Again, there's public hearings, and we're invited to those. We can go. They're public. Anybody can go. Press shows up. They report on it, et cetera, right? Government gets to appoint. So obviously we get to vote on who, gets to be, or the president gets to appoint. We get to vote on who gets to be the president, and our Congress people, senators in particular, that, would vote, okay? Congress can abolish an agency. That doesn't happen very often, right? Okay? But they can certainly alter the agency's budget. They can definitely redefine the agency authority and jurisdiction. Again, with the power change, or the sea change that we've seen in government over the past year, they're busy doing that in a lot of cases, appointing new heads that have, different ideas about where the government should go, different ideas about environmental protection, all kinds of things, right? I could probably go on for hours. We talked about this a little bit, right? Proposed rules are published in the Federal Register, and we're allowed to comment. They don't necessarily have hearings in Havre, Montana for every single rule, in fact, hardly for any, but we can certainly go on there and we can comment. Now, what generally happens is, people in big industries, and they probably have industry advocates or industry groups, like a bankers association that would monitor proposed rules and whatnot for the banking industry. And then, of course, if there's some that they think are adverse, they would lobby against those, right? But you and I could do that as individuals as well. Reviewability. So agency decisions are reviewable. So you don't give up your right to court just because there's an agency, right? Unless the statute precludes review, which I don't think happens too often, or unless the agency's action is committed to agency discretion by law. Again, that would preclude review by the judiciary, which again just does not happen all that often. So the aggrieved party, so somebody subject to maybe rules and regulations, they have to be harmed. Okay, so you have to have standing just like you would in other court cases, right? The harm can be economic or non-economic. So judicial review, first, rules and regs have to be within the legislative grant of power. And we're having this big fight right now, so you're seeing this actually happen with the immigration deal. And, President Trump has proposed some travel regulations, for folks from certain countries, that they're going to be subject to a little bit more scrutiny as they come in. And we've seen judges that have jumped in and said, no, you can't do that, right? And so they've prohibited that. And then those actions, in some cases have moved forward, and Trump's changed the regulations to try to fit, with what the judge might have said. And so, it's a constant kind of battle back and forth. And in those cases, oftentimes, there's trials or lawsuits and whatnot that happen. But in these cases, judges have jumped right in because they felt, maybe that the law had such an impact that they needed to rule right away. Again, is the delegation of power valid? And that's probably, some of the discussion that they have over these new rules that Trump is proposing. And believe me, Obama proposed far more. He set records, I think, if I'm not mistaken, for executive orders in terms of rules and whatnot that came down during his administration. So definite, right? Does the delegation of authority, or does it violate due process for the folks? Did it violate due process? Did they go through the right procedures, to establish the rule? Okay. Agencies' powers are obviously limited to certain areas. Okay. The authority is broad, generally speaking. When we created Obamacare, and in spite of the fact that it was many, many, many pages, you also knew that there was a lot of it that was kind of left to the discretion. They had to write rules in order to implement it. Okay, and that's where the broad authority comes in. So, one of the things that they would look at for judicial review is the authority exceeded. And kind of like both the delegation being valid and the authority exceeded has to do with maybe some of the immigration things that Trump is doing. But they'll also look at the constitutionality of it as well. Okay, and that's a little bit different maybe than this the validity of the delegation or the authority. And then that's one of the things that they're looking at with Trump's proposals for the immigration is it constitutional, or are we discriminating against a specific group of people? Judicial review is generally limited, right? Agency authority is limited because it's delegated from the legislature. They have to develop their own rules of procedures. And courts lack authority to substitute for the agency in terms of the agency's expertise in that area, maybe. The doctrine's exhaustion of remedies basically says that you have to exhaust your remedies within that agency. And a lot of times this happens, I see it in employment things. Okay, if you feel you've been discriminated against, you have to first file your claim with either in Montana, the Human Rights Bureau, I believe it is. At the federal level, it's the EEOC, or Equal Employment Opportunity Commission. And you exhaust your remedies with them. In other words, you have to go through all their procedures. And only if you've done that, and they often issue what's called a right to sue letter, they might find that your case doesn't have the kind of merit that you think it does, and so they're not going to take your case, and so they'll send you a letter that says, okay, we've exhausted our review of this, and you have a right to sue now if you prefer to. Okay. Primary jurisdiction, again, the jurisdiction that's granted over certain areas. Some are really obvious, some are not so much. Years ago, when they were trying to establish a do not call list, for example, so you didn't have to get all the telemarketers calling your home phones. Most of you guys with cell phones don't even remember that, although I think there is a do not call list for cell phones too. There was a bit of a who had the jurisdiction? Was it the Federal Trade Commission or was it the Federal Communications Commission? An Equal Access to Justice Act means that just because you may not have a lot of money, you still can take your case and you may be reimbursed actually for some of your expenses. So the court presumes the findings of fact are correct from the agency, right? But they'll analyze the agency's proceedings. They don't reweigh evidence. They don't make independent determination. Again, they don't substitute its view. Okay. So we just talked about this 2 slides ago. But the equal access to justice, right? Successful business challenge can be limited. Individuals that have a net worth of less than $2 million can get their fees back, right? If they've been inappropriately regulated, I guess you would say. And businesses with a net worth of less than $7 million can also get reimbursed. But the government doesn't pay if the actions were substantially justified. And there's some egregious events, that happen. Seizures of assets because especially business assets, because government thought that a business might have connections to drugs just because they were dealing in a lot of cash. And those types of things, they're bad, and so businesses do go after it. Cost of business, right? And this is, of course, the argument that we're hearing right now and why we're pausing a little bit on regulation, because regulation is a form of taxation. As we pile these regulations on, it gets to be very, very expensive. Okay. It forces bureaucracy in businesses. So yeah, we have to, big banks have compliance departments, and that's all they do basically is they exist to comply with federal and sometimes state regulations, and they pay millions of dollars a year to these folks to try to ensure that they're in compliance. It stifles competition and innovation, and it's very true. Big businesses can more easily handle the cost of regulations. If you're just a startup, if you're just a startup, it becomes very, very difficult to comply with a lot of those costs and whatnot. Okay. Now, they've done some things to mitigate that, because if you only have a few employees, you don't necessarily have to comply with EEOC regs like you do if you're a bigger business, et cetera, or FLSA, Fair Labor Standards Act regulations, like you might have to otherwise. But nonetheless, it's still proportionately, small businesses tend to pay more still for regulations than do big businesses. Okay, and the paperwork. They're arguing about tax reform right now, and they're talking about how much it costs us just to file our taxes. Well, I've heard estimates that our regulatory framework, and this is not an indictment or a criticism necessarily of all of our regulations, but that our regulations cost us maybe from $1 to $2 trillion that you and I pay in extra cost for goods and services, right, because of the regulations that are there. So is there too much or too little, right? If the car industry was deregulated, would you trust car makers to build safe and efficient cars? And a lot of the safety standards have come as a result of government requirements, right? If the drug industry were deregulated, would you trust drug companies to provide safe medicines? And there's criticisms right now of the FDA because they don't as quickly approve some of these drugs, especially for people that are in stage. Right? If you're in stage, why can't you try an experimental drug? And there's criticism of that. So if you could control regulation, what would you do? Good question, and good luck. There you go. All right, so ends our discussion of the regulatory process. Enjoy.